Late in the day, on July 24th, 2026, at exactly 5:15 in the evening, a piece of paper was walked into the Vinton County Courthouse in Ohio. It was a Friday. The building was almost empty. Most of the staff had already gone home. On that paper was one sentence, just one. It said, and I want you to hear it word for word, defendant's competency to stand trial has been raised. That is the father. That is Gary Siders II, 36 years old, the man at the very center of what people are calling the Ohio House of Horrors. But that one sentence was not the whole story. It was not even the strangest part of what got filed that afternoon. Because right underneath it, tucked into the same motion, his attorney asked the judge for something else. He asked the judge to seal it, to lock it away, to hide every single page that comes next from your eyes and mine. Two requests. One piece of paper filed at the end of a Friday when the least amount of attention would be paid. That is the story I need to tell you tonight, because what looks like a normal legal motion is really two very different plays stacked on top of each other. And once you see how they fit together, you cannot unsee it. Before we go any further, I need you to understand what this motion actually is, because the words sound scary and the internet is already running wild with what they think it means. A competency motion is not an insanity defense. Let me say that again, slower, because it matters. It is not the father saying he did not do it. It is not the father saying he was crazy at the time. It is not a way to walk out the front door of the jail. What a competency motion asks is very small. It asks one question. Can this man, right now, today, sit next to his lawyer and understand what is happening in the room? Can he help his own defense? Can he follow along when a judge speaks? Can he tell the difference between the person prosecuting him and the person defending him? Can he answer a question with an answer that makes sense? That is all it asks. Nothing more. Nothing about guilt, nothing about innocence, nothing about that house, nothing about those 16 kids. If the answer comes back no, the case does not go away. The 16 felony counts do not go away. The children do not go away. Nothing on the record gets erased. The case just stops. It freezes, like someone hit pause on a movie right in the middle of a scene. The father would be sent for treatment. Doctors would work with him. Months would pass. Sometimes years pass. And only when the doctors say he is ready does the trial begin again. And only then does everyone walk back into that courtroom and pick up where they left off. So when you hear the word competency, do not hear the word freedom. Hear the word delay. Hear the word wait. Hear the word later. Because for 16 children sitting in hospital beds and foster placements right now in Ohio, later is a very heavy word. Later is not a mercy. Later is a bill somebody else pays. Now let us walk through the second door, the one his attorney did not want you to notice. In the same motion, right there in black and white, attorney R. Lee Roberts asked the court for permission to file every supporting document under seal. Sealed, as in you do not get to read them. The press does not get to read them. The public does not get to read them. Only the judge, only the lawyers already inside the case, nobody else. And his reason for asking? Read it slowly with me. He said the documents contain, and I am quoting him directly here, highly sensitive mental health information or information directly reflecting the psychiatric condition of the defendant. Now stop. Think about what those words mean, not what they sound like, what they mean. For an attorney to write those words in a court filing, something has to exist. Some paper, some record, some diagnosis, some hospital visit, some evaluation done by someone somewhere at some point in this man's 36 years of life. You cannot ask a judge to seal something that does not exist. You cannot say the papers are highly sensitive if the papers are empty. Judges are not stupid. Attorneys do not file empty motions. So there are papers, there is a history somewhere. And the very first thing this defense team decided to do with that history is to make sure you never see it. That is not a small choice. That is a strategy. It is a decision made on purpose at a specific time of day at the end of a specific week. And the timing of that strategy is the piece that made me lean forward in my chair when I first read the filing. Let me put two dates in front of you, just two. Date number one, July 14th, 2026. That is the day the first gag order came down in this case. It told the lawyers, the investigators, the prosecutors, the court staff, everybody with a badge or a briefcase to stop talking to the press. It shut every official mouth in the case. Date number two, July 24th, 2026. That is the day we just walked through. The competency motion, the request to seal, the 5:15 p.m. filing on a Friday, 10 days, just 10 days apart. Same case, same attorney. R. Lee Roberts on both filings. I am not going to tell you what that means. I am going to let you sit with it. Because when the same lawyer in the same case in 10 days first shuts the mouths of everyone who could speak on the record and then asks the court to lock away the paper trail of his client's mind, a picture starts to form. A picture of a defense that is not fighting on the facts, a defense that is fighting on the silence, a defense that is not trying to explain what happened, but is trying to control what the public can see and hear about what happened. Now, is that legal? Yes, it is completely legal. Every defendant in America has the right to a strong defense, and gag orders and seal requests are tools that get used every day in serious cases across this country. I am not saying anything different. I am not saying anything unfair, but I am saying this: a defense built on silence works. It works on juries, it works on judges, and it works on you and me sitting on our couches trying to understand what happened to 16 children in a small Ohio town. Because you cannot be angry about what you cannot see. You cannot organize about what you cannot read. You cannot demand accountability for a story you were never told. And this defense team seems to understand that better than anyone else at the table right now. So let us do something the defense would very much prefer we did not do. Let us try to guess what is on those sealed pages. Not the words. We cannot know the words, but the shape of them, where they might have come from. What kind of documents would have to exist for a lawyer to write those words? Here's what investigators have said publicly about this family. And I want you to listen closely because it changes what this seal request means. For years, according to state records and multiple public statements, the Siders family drifted through several Ohio counties. They moved, they changed addresses. And along the way, they did something a lot of struggling families do not do. They avoided the paper. They avoided the school system, at least in a formal way. They avoided regular medical care. They avoided the kind of government records that most American families leave behind them, like footprints, birth records with follow-up visits, enrollment forms, doctor visits year after year, dental records, vaccination records, school photos, report cards, all the ordinary paper trail of an ordinary American childhood. Most of it, according to what the state has said publicly, is missing for this family. That is what the investigators have said. That is on the record. So here's the question that sits in my chest. If this family avoided the paper for years, where did the paper his lawyer wants sealed come from? Was there a hospital visit somewhere, an emergency room in a town they passed through, a court-ordered evaluation from a different case in a different county that we do not know about yet, a jail intake screening from an arrest we have not been told about, a social worker's file from a decade ago in a county they lived in briefly, a military record, a workers' compensation claim? I do not know. And that is the point. Nobody in the public knows. And if the seal is granted, nobody in the public ever will. The paper will exist, the judge will read it, the lawyers will fight about it, and on the outside, we will only ever see the outline of the shape it left behind. The absence of records for this family for so many years is exactly what makes the sudden appearance of records now so loud. Something exists. Something was written down about the father's mind at some moment in his life. And the very first thing this case is going to do is bury it before you can read it. Now, I want to talk about time, because time is the piece nobody in the courtroom is going to say out loud, but it is the piece that matters most to the 16 kids at the center of this. In Ohio, when a competency motion is granted, the case goes on hold. The doctors take over, there is an evaluation. That can take weeks by itself, sometimes longer if the state's psychiatric hospitals are backed up, which they often are. Then, if the defendant is found not competent, there is what the law calls restoration. That is the process of trying to get him to a place where he can stand trial. Medication, therapy, regular check-ins with mental health staff. Court reviews every so often to see if he is ready yet. Restoration in Ohio can take a very long time. In some cases, it takes 6 months. In some cases, it takes a full year. In some cases, it takes multiple years, with review after review, hearing after hearing, each one deciding that the defendant is still not ready, so wait a little longer. Come back in 90 days. During all of that time, the trial does not happen. The witnesses do not testify. The children do not have to face what a trial would ask them to face, which sounds like a mercy on the surface, but it is also a delay, a very long one. And delay is not the same thing as protection, because those same children are also trying to heal. They are in foster homes. They are in therapy. They are learning what a normal meal looks like. They are learning what a bed feels like. They are learning what it feels like when an adult in the room is not a threat. The younger ones may not remember what happened to them. The older ones will remember every second. And a case that stretches on for years is a case that lives in their heads for years. Every court date, every anniversary of that June 30th rescue, every time a lawyer calls them to prepare for a testimony that keeps getting pushed. Every time a therapist has to walk them through it again because the calendar demands it. The father's clock, if the motion is granted, gets slower. The children's clock does not. It never does. Their clock keeps ticking at full speed, whether the court is moving or not. That is the cost. That is what a piece of paper filed at 5:15 on a Friday afternoon actually purchases. It purchases time. And time in a case like this is not free. Somebody is paying for it, and it is not the man in the jail cell. Let me bring you back to where we started, to that one sentence on that one piece of paper. Defendant's competency to stand trial has been raised. 10 words filed on a Friday in a small county courthouse in Ohio at 5:15 in the afternoon when almost nobody was watching. And attached to those 10 words is a second request, a request to seal, a request to hide, a request to keep the story of one man's mind out of the hands of the public that is trying so hard to understand this case. The court is being asked to look at one man's mind. And in the very same breath, the court is being asked to look away from the reason why. That is what happened on July 24th, 2026. That is where this case is right now. In the meantime, Gary Siders II sits at the Southeastern Ohio Regional Jail on $300,000 bond. His misdemeanor public indecency hearing on a separate matter has been pushed to August 13th. And every filing that comes next in his case will land in the same courthouse where two of the biggest doors in the American legal system are already halfway closed. I do not know what the judge will decide. I do not know what is on those pages. And if the seal is granted, none of us ever will. But I know this. When a defense begins with silence and then adds more silence on top of it, the loudest thing in the room becomes the empty chair where the truth was supposed to sit. Stay with me on this case. There is more coming. And I promise you, we will read every filing they let us read together. Every page, every date, every quiet Friday afternoon.